Yes, Mr. Smith.
Thank you, my lord. I had promised to give you a reference earlier in relation to when Mr. Curry refers to females, he included Mrs. Bethel. That's to be found at EB 1430, 1430 at lines 21 to 27.
Yep.
Thank you.
Yes.
I was waiting for you to indicate if you were ready.
Ah.
Sorry.
Yes.
So the majority of the Court of Appeal held that arresting Mrs. Bethel for immigration purposes and giving her no more information than that as the reason for her arrest did not meet the minimum common law requirements of a lawful arrest in Article 19 of the Constitution and as required by the common law. We submit that the state fails to identify any error in that reasoning. Firstly, we say that the case for the government is that the arrest and detention was based on a suspicion that she was in the Bahamas without legal immigration status. Secondly, they say Ms. Bethel understood the reason for her arrest and detention. Thirdly, they say the suspicion was reasonable and, importantly, pending verification of confirmation of her spousal permit. The ground of appeal was ground 2 of their appeal, wrongly says that the fact that Mrs. Bethel was legally in the Bahamas was confirmed, and I emphasize the word confirmed, around 3 p.m. on 13 December at paragraph 134 of the judge's ruling. And paragraph 134 does not say that. My lords, and that's at page 42, paragraph 134 of a ruling is at page 42 of the EB. We say that this misconception by the appellant is at the root of the misconceived appeal. Justice Charles held at paragraph 8 of her ruling, which is EB 15, that Mrs. Bethel presented a copy of her spousal permit to the police before she was arrested. And at paragraph 134, EB 42, she noted, it ought to have been apparent to the officers that Mrs. Bethel had legal status, dispelling any suspicion that she had no legal immigration status. As such, Mrs. Bethel's detention was unlawful from 3 p.m. on Saturday, 13 December 2014, when she was released into Mr. Bastian's custody about 3:55 p.m. As it has been found as a fact by the judge that her spousal permit was shown to the police before her arrest, and the validity of it could not be established until Monday, we submit that there was no rationale for the trial judge to find that Mrs. Bethel was legally detained before 3 p.m. on Saturday and somehow became unlawfully detained after that. The very simple point...
Sorry, but isn't her explanation that it had been verified by 3
Yes.
p.m.?
No, she never made that finding, my lord. But...
Well, paragraph 134, she says the fact that Mrs. Bethel's profile document created at the CDU stated that she had a valid spousal permit is strong evidence that she had to be detained, i.e. beyond that point. In other words, it had been checked, that the immigration authorities' records had been checked by that stage.
No, there is no evidence of them having been checked. They weren't checked until Monday morning. That was the whole reason for immigration keeping her. That's why she was sent that night to the detention center for immigration to process her, and that's found in Ms. Moss's evidence. There was never a finding that there was any verification. The detention record was merely prepared by the police at the police station. There was nothing.
Sorry, but this is talking about a profile document created.
It was the police profile document.
Right.
Which simply said.
3 o'clock in the afternoon was the time she was interviewed.
That's
we see
correct.
that in paragraph 9, so that's what was happening at 3 o'clock.
Yes. The profile is to be found at EB 462. And the profile merely states, at that time, and confirms in that document that she had her spousal permit. But it has also been found by the judge that she had a copy of her spousal permit from 1 a.m. before she was arrested and kept showing it to the police at every opportunity that she could. So nothing changed between 1 a.m. and 3:55 p.m. Sorry, whatever time she was
3 p.m. was the
3 p.m.
finding, I think.
So in their submission, in their grounds of appeal at EB 325, they wrongly state at paragraph 15 that her spousal, the fact that she was legally in the Bahamas was confirmed around 3 p.m. Nothing was confirmed. Hence her continuing detention until Monday morning, by which time the immigration offices were open, and you may recall the evidence that they didn't have their information on any computer system, and so they couldn't check it over the weekend. The only time they could do it was when the offices opened on Monday morning, and that's when Ms. Moss confirmed that she had been issued a resident spousal visa. And that mistake is repeated at paragraph 23, page 2792, where the appellants say that once the true position had been verified, the suspicion evaporated and she ought to have been released. And it's again repeated at page 2797, paragraph 41, where they concede once the position had been confirmed at the station, the judge held that the detention became unlawful. But our position is that she was showing a copy of her permit from 1 a.m. for the entire day. She showed it to everybody who would listen to her. And nothing new at all came to light or was established between when Mrs. Bethel showed the police the copy of her permit before she was arrested and when she showed the same document to Inspector Bowles at 3 p.m. on Saturday. See, at paragraph, page 15 is where, paragraph 9 of of Justice Charles's judgment, where she says, Inspector Bowles noted that Mrs. Bethel is the spouse of a Bahamian, and she saw a copy of her spousal permit. Inspector Bowles informed Superintendent Shanton Knowles that Mrs. Bethel had a copy of her spousal permit. And so all they did was notify or place on the detention record, which is at 462, Subject was arrested at Twilight Restaurant and Bar. Subject claims to be married to a Bahamian, and RSP is valid February 2015. She still, it was the same permit that was produced.
What does RSP?
Resident spousal permit. You'll see that reference a number of places, Millard Sales. RSP. It allows a person to reside and work in the Bahamas who is married to a Bahamian for a period of 5 years. So we say that if the representation, and I'm not going to my actual case where all the details and the references are in support of that, but in summary, if the representation of the copy document at 3 p.m. meant that she should have been released at that point, and her detention thereafter was unlawful, and this is the implication in Justice Charles's judgment, then her detention must have been unlawful from the very outset as she presented the copy of the document to the police before arrest. And I don't believe there is any evidence that this profile was prepared at the police station on Saturday afternoon. My friend can correct me if I'm wrong, but this is a document prepared and signed by Mr. Beneby, who is the Deputy Director of Immigration, on the 15th of December, which was the Monday.
Yeah, it's dated at the top, the 14th, which was the
Sunday.
Sunday.
So it wouldn't have been prepared at the, thank you, my Lord, it wouldn't have been prepared at the police station. She was, on the 14th, she was in the custody of the Immigration Department. So even if this is somehow proving verification, then it's on the Sunday that she was verified, if this document somehow proves it, but it doesn't. I don't recall if the evidence discloses who prepared that document.
No, it looks as though most of the document's been filled in on the 14th, and then Mr. Benedy has put on a note at the end in different handwriting ordering the preparation of a release order on the 15th.
So I would suggest that this was prepared at the Immigration Department on the 14th.
Right, and in fact, I think that is what Mr. Beneby says. If you look at page 401, paragraph 5, he says on 14th December she was committed to the detention centre pending verification of her immigration status.
Yes.
A check of our records revealed that Mrs. Bethel is the spouse. So I thought I had read something to that effect, that it looks as though there was a check carried out.
There eventually was.
And on the 14th, and from the check it was verified that there was indeed a valid residential spousal permit. So, I mean, whatever the legal significance of that, it does seem that verification checks were carried out and were found to be positive.
On the 14th.
On the 14th,
Yes. I accept what your lordship has said, but my recollection is that there was...
But sorry, you had said to us before that nothing had changed between the point of arrest
and the judge having found that at 3 p.m. on Saturday...
Saturday the 13th.
That's the 13th, Saturday the 13th. Thank you, my lady. Saturday the 13th. So the judge found that as a result of the... Well, she didn't even say confirmation. What did she say? 134. She refers to the profile document is strong evidence that does not support the government's position that she had to be detained
And that's the document at 462 that
Yes,
you're referring to?
which came into existence on the 14th, we now have determined. So her logic in saying that the unlawful arrest began only on the 13th of December, which was the Saturday, because by that time, as the appellants say in their grounds of appeal and in their case, that it was confirmed and then verified at 3 p.m. on the 13th, is completely illogical. If the judge found that it was when the permit was verified that the unlawful detention began, she could not have found it on the basis that it started at 3 p.m. on Saturday, the 13th.
So are you saying in paragraph 134 the judge has made just a factual error as to the time of verification? Is that what you're saying?
No, I'll come back to that in a moment. What I'm saying is the judge's reasoning for having found that, despite the fact that she also found, and this is very confusing, despite the fact that she also found that Mrs. Bethel was producing a copy of her permit from the time, before the arrest and throughout, it was illogical for her to later say that the fact that she had produced the permit at CDU, where she thought the profile had been created, meant, having found that at paragraph 134, that the profile document was strong evidence which does not support the government's position that she had to be detained. She is wrong there because that document wasn't produced at CDU. And as Mrs. Moss also.
Sorry, you just said the profile document was not created at the CDU.
At the CDU.
Right. I just want to make sure, well, first of all, that we're looking at paragraph 134 of the judgment. We're talking about the same document. That's page 462.
Yes.
The judge says it was created at the CDU. So are you saying that's another error, that she's just misunderstood the evidence?
I'm saying, my lord, that whether it was created at the CDU or not,
Okay.
the profile, let me start again. The judge found that she had been lawfully arrested because she had not verified her permit until Saturday afternoon at 3 p.m. And we say that that cutoff date by the judge was not logical because the same document that was given to Inspector Bowles, I think, at the police department on Saturday afternoon was the copy of the permit that she had been showing to the arresting officers at 1 a.m. from 1 a.m. on Saturday morning. It was the same document. So I suppose the judge must have misunderstood that the profile document had been prepared and there had been a verification at the CDU department at 3 p.m. on Saturday afternoon, when in fact it wasn't. This profile document, as I think we all agree, is dated the 14th of December. And it was on Monday morning, on the 15th of December, that Mr. Bastian then, sorry, Mr. Beneby then ordered that the release order be prepared.
Can I ask you about something slightly related but slightly different? I've been looking at the witness statement by Superintendent Curry, and he says that he wasn't aware at the time of the arrests that any of the women had a spousal permit. Do we know who actually arrested?
We do not, my lord.
We don't know who actually
We
arrested.
hear about Mr. Fernander on the detention record saying that he was the arresting officer, as the Court of Appeal pointed out. Mm-hmm. We hear Mr. Curry variously saying that he did or didn't arrest them. Mm-hmm. We have evidence that the arresting officers, I think there were 4 or 5 of them, and 2 male and 2 or 3 female in the club, they went about seeing everybody's papers. Mm-hmm. So we don't know who the officer was that arrested. Right. Right. What in fact happened, I suggest, my lord, is that everybody who had a foreign accent was just going to be arrested en masse and put on the bus. Yeah. So the only person that the government proffered to give any evidence about the arrest was Mr. Curry, and he may not have, in fact, have made the arrest.
Yes, I mean, in his statement, he says that on hearing foreign accents, the women were questioned about their status and are asked to produce their passports or documents. And on reviewing the documents, the officers suspected there was a breach of the immigration laws. Then he goes on to say that he wasn't aware that any females had spousal permits. That's page 414.
So, my lord, it's a contradiction. If indeed one of his officers, as he says, conducted an investigation or a review of each of the women's documents, then they would have seen that Mrs. Bethel had a spousal permit, and she should not have been placed on the bus. And in his
sorry, just on his evidence, I think I'm right in saying that in cross-examination, he also said that there had been intelligence about immigration offences being committed by persons at the bar?
My lord, his position was, I'm not going to tell you what my intelligence was.
No, but I think he did say, and that was the effect of it. Is that not right? I thought I had read that.
He had information that there was exotic dancing going on at the club. See, this is the problem with this arrest. They lump everything under immigration purposes. And that's why we're having difficulty pinning down what did.
Yeah, sorry, I think I had remembered correctly. It's page 1367. What information were you provided with? This is lines 9 following. There were suspected illegal immigrants performing exotic acts in the club.
Right.
Right. I just wanted to get the evidence and the factual position clear.
He says, Lord, you're right. There were illegal immigrants conducting exotic dances. So that is even more reason why they shouldn't have arrested Mrs. Bethel, because in his cross-examination, he goes on to say that he observed women, scantily clad, etc. But specifically, Mrs. Bethel was at the bar as a bartender and was not scantily clad. So even if his information was correct, and he went there to find the exotic dancers at the club, she was not one of them, and he confirmed that, although he says that she wasn't scantily clad, and she had her spousal permit, so she didn't even fall within the information section of his thinking. If your lordships will remember, there was a considerable amount of time spent in cross-examination on his only having suspicion before he went there based on the information, and then when he got there, he formed the reasonable, he came to the conclusion that he had reasonable cause to suspect the women breaching the immigration laws because they were scantily clad, to put it in summary form.
So can I just take you back to the point you're making about the timing?
Yes.
As I understand it, your submission is that the judge thought an important cut-off point was Saturday at 3 o'clock.
Correct.
Because thereafter, she's saying it was an unlawful detention.
Yes.
Your submission is that all that could have been happening at 3 o'clock on the Saturday was a looking at the same spousal permit as had been shown throughout, and that the point about looking at the records could only have happened the next day, so that we have an illogical, as I understand your submission, approach to the rest of Saturday.
Yes, my lord.
Thank you.
At all material times, from the time she was arrested at 1 a.m. until her release, the only document that existed was the copy of her spousal permit. Verification occurred at the immigration department the next day.
I suppose it might be said that in paragraph 134, if the judge has made a mistake, and it's also the case that verification is the significant thing from her analysis, which I think it is fair to say from 134, she does regard as a significant thing. It seems to be an error of fact in your client's favour. I'm not saying that what the result would have been otherwise, but if the key thing is verification, and that only happened on the 14th of December, that insofar as a mistake's been made, it's operated in your client's favour. Is that right?
Yes, my lord. I'm also saying, however, that there's no law. It is not lawful to arrest a person simply to verify whether her copy permit is or is not a forgery. They don't make. There's no evidence that they suspected of it of being a forgery. No grounds were set out.
The judge goes on to say at 135, the main question is whether she had a copy of her spousal permit when she was arrested.
But the judge made a finding of
Paragraph
fact at paragraph 8.
Because she says the immigration department was not prevented, this is 135, not prevented from investigating the genuineness of her marriage or putting their suspicion to her. However, it could not be used as a reason to detain her.
Yes, on the issue of her marriage. But if we go to paragraph 8,
8, yeah.
at page 15,
Yeah, she's made a finding.
at all material times she was in possession of a spousal permit to remain in the Bahamas. So having found that, also it's illogical for her to have found this hiatus between when she was unlawfully arrested and lawfully arrested. Yeah. And she found as a fact at paragraph 8, she showed the police a copy of her spousal permit, giving her legal permission to remain in the Bahamas. So the arrest must have been, if that was the basis upon which, that she had no legal status in the Bahamas, then the arrest must have been unlawful from 1 a.m. Friday morning, forever, for the entire time. And that was the mistake that, unfortunately, it was contradictory for the judge, and that's, we say, illogical, for her to have found that at all material times she had a copy of her spousal permit, giving her legal permission to remain in the Bahamas. Had any officer actually applied their minds to looking at her document, they would have seen the spousal permit. And having seen the spousal permit, even if they thought it was a forgery, which they don't allege, because she did have it and they knew her place of work, it was not necessary, as Section 9 requires, to arrest her. They could have used their powers to ask her to come to the immigration department sensibly on a Monday. And the judge actually finds that, or makes a comment about that later, when she says, where's that section where the judge says? Where the judge says it was unfortunate they could have released her earlier. I'll find it. Thank you, Ron. Yes, the judge, in fact, at page 41, I'm grateful to my friend, paragraph 131, 4 lines down, she says, in my judgment, a more reasonable, this is where she's dealing with Mrs. Greensmith suggested that detaining Miss Bethel was the only way to secure her presence. Although this is an attractive argument, it does not follow from a failure to utilize Section 8 power to summon and investigate that the standard required of Section 9 has not been met. In my judgment, a more reasonable approach could have been utilized, especially having regard to the fact that Mrs. Bethel has a copy of her spousal permit in her possession, which Inspector Bowles saw and alerted Superintendent Knowles to on Saturday, December 13th, around 3 p.m. And Mr. Hanlon agreed to see to it that Mrs. Bethel appeared on Monday, 15 December, at the Immigration Department.
So we see there the focus on the 3 p.m. on the 13th
Yes.
of December. Can you help us with the evidential references that the judge is referring to there?
Yes, my lord. It's in our they are in our case, and my friend will find it and will inform me, and I'll take your lordship.
Thank you.
So we see that had the judge logically applied her mind to it, although I'm beginning to see that maybe the judge was focusing on the verification on the profile document as the time when the arrest was thereafter.
The judge seems to find that her spousal permit was presented at 3:30 on the Saturday. That's paragraph 8 of her.
As well, yes, my lord.
Does she elsewhere expressly find it was shown to the police earlier than that?
To the police earlier?
Yes. Well,
Yes,
I may have missed the paragraph.
That's paragraph 8, my lord.
Paragraph 8.
Yes. She says, third line down, she showed the police a copy of her spousal permit giving her legal permission to remain in the Bahamas.
Sorry, paragraph 8, did you say?
Yes, page 15.
Oh, wait a minute. Yes, hold on.
The police insisted, a copy of her spousal permit giving her legal permission to remain in the Bahamas. The police insisted that she board a bus, which was outside.
Yeah.
I submit there was absolutely no thought given by the policeman as to whether she had or not committed an offense. She was a Jamaican, she was foreign, there was a raid at the Twilight Bar. Everybody who spoke, who had a foreign accent.
I mean, some thought was given to it because documents were asked for. So they didn't just round people up, and the evidence doesn't suggest they rounded them up and
Agreed,
put them on the bus without checking documents.
Agreed, my lord. But I submit that makes it even worse, given that she did have a copy of her permit, and she showed it to the police officers. She should not have been put on the bus. There was no reasonable cause to suspect that she had committed an offense, or that she was an illegal immigrant. Or even if they had some kind of suspicion, that she should have been detained. When even the judge says, given her circumstances of having a copy of her permit, a more reasonable approach would have been to let her come in on Monday.
I mean, it's right to point out that the finding at paragraph 8 is essentially accepting Mrs Bethel's evidence at page 355, where she says in terms I showed
Yes.
a copy of my spousal permit to the police officer.
Lord, I have a whole
before.
bunch of references I'd like to take you to, but we don't have 3 days.
Right.
She also finds at paragraph 8 that the arresting officer was Superintendent Curry.
Yes, she does. But he never spoke to her in his evidence. He says he kept away from them. He didn't want to be accused of, Yeah, she showed it to the arresting, or the other officers. So, moving on if I could, because I'm running out of time. We say that based on all that I've said, the unlawful arrest occurred from 1 a.m. in the morning. And we say that the Court of Appeal correctly applied the legal principles of, the correct legal principles, and doomed the arrest from the start to be unlawful. And as your lordships will have seen, there are 3 criteria that are necessary to fulfill an arrest under the Immigration Act. One is to suspect that an offense has been committed. Number 1, the appellant's defense at page 193 of the record failed to specify the offense or even the type of offense that Mrs. Bethel was reasonably suspected of having committed. At page 195 to 196, the defense simply stated that she was arrested, quote, for the purposes of determining whether an immigration or other offense had been committed. Not that they suspected that she had committed an offense. She was arrested, quote, for the purposes of determining whether an immigration or other offense had been committed. We say this amounts to an admission that there was no particular offense in mind when she was arrested, and that the purpose of her arrest was simply, and I emphasize again, to determine if she had committed an immigration or other offense. And that's, so there was no evidence adduced of any suspicion of her having committed any actual offense. There were so many other conflicting reasons for her arrest, which I took your lordships to the relevant part of our submissions of our case. There was no evidence given by Mr. Curry, or that was pleaded, that she was suspected of any particular offense. At the 3rd day of his cross-examination, he came up with the idea that she was in control or in charge of the women. But for 2 days of cross-examination, that never occurred to him. I don't know how it dropped into his mind, but it suddenly did. But it's not pleaded, and it wasn't in any of the evidence. In the end, Justice Charles found that Mrs. Bethel was arrested for immigration purposes and detained for, quote, verification of a copy of her permit. And I simply say, my lord, and my lords, I submit that there is no power to arrest to verify if a spousal permit is or is not valid. So we say that it is not a proper legal basis to arrest and detain for not having original papers in a person's possession. Lord Briggs asked me that earlier. You don't have to have identification papers, and certainly you don't have to carry around an original of your permit from the Immigration Department. Certainly, if you are arrested in proper circumstances, there is an evidential burden thrust upon a person charged at trial to produce a document showing that they were given leave to enter into the Bahamas. Usually it's stamped in their passport or some other document. But the presumption of innocence applies. People cannot be arrested arbitrarily. There has to be reasonable cause, and they have to have the necessity of arrest. And I think I don't know much more that I can say about that. my lords. We say the Court of Appeal was correct in their analysis of the case. And today, there's no clarity on what legal basis she was arrested. And so, in conclusion, we say that it was perverse to find that she was properly arrested. And in summary, the fact that whether Mrs. Bethel did or did not know the reason for her arrest is nothing to the point. That is not the basis upon which a person can be arrested or continue to be detained in the circumstances of this case. So we say that she was unlawfully arrested and there was no necessity to arrest, and the Court of Appeal was correct in their analysis of the proceedings. If there's anything else, I'm trying to give my time for Mrs.
Of course, yeah. I just wondered if your team had managed to come up with the references for paragraph 131 in the judge's judgment, the evidential references.
I didn't hear the beginning of what you said.
Whether your team had come up with the evidential
yes.
references.
Yes. It's at 462. That's the profile. Where's the two? They just gave them to me.
Oh, thank you.
Oh, here they are. At 404, page 404, paragraph 18, and 1610, paragraph 130. No?
Sorry, that was first for page 404, paragraph 18, and the second was page 1610,
paragraph 131.
131.
So
Not sure that's right.
So maybe those are not the right
doesn't have a
references.
paragraph 18 on it.
I don't think 404 is correct. That's
Okay.
the witness statement of Thea Moss.
So,
I mean, there is a witness statement of the lady who interviewed her on the afternoon.
yes.
At 3 o'clock, which coincides with the
Yeah.
I mean,
3 p.m.,
yeah.
which is Bowles, and she gives a short witness statement describing her interview.
My Lord, Sales, what was your question again that I had to find the reference?
Paragraph 131 of the judge's judgment, where she says, more reasonable approach could have been utilised, especially having regard to the fact that Mrs. Bethel has a copy of a spousal permit in her possession, and then this, which Inspector Bowles saw and alerted Superintendent Knowles on Saturday, 13th December, around 3 p.m.
Yes.
It was the evidential references behind that, because that seems to be the seed for the 3 p.m. on the Saturday timing, which the judge then uses as the cut-off in 134. So if you could assist us with what the evidential references the judge has in mind.
I think it's the Bowles witness statement, which is at page 416. Oddly enough.
416.
Yes, at end of paragraph 7.
Yes. So at paragraph 7, it says she provided a copy of her spousal permit while in police custody. So again, that wasn't.
Doesn't quite say when. Doesn't quite say when. Bearing in mind how long she was in custody.
I'm still slightly, we can't take up too much time on it, but I'm slightly mystified because paragraph 9 says that when this witness asked for a copy of the resident spouse permit, she stated she did not have it on her.
That's the Amos on.
Oh, that's the Moss. Sorry, that's. Oh, I'm so sorry. Yes.
There was a lot of cross-examination on whether she did or didn't have a copy of her permit, and the judge eventually found, and even the statement of fact and agreed facts in this case, she had a copy of her permit.
Yes.
So she showed it. Yeah, there's no question that, and a finding of fact that she showed it to the arresting officers.
All right. Thank you very much.
I yield.
Better not take up more time on this.
Thank you very much, Mr. Smith.
Thank you, Mark.
And Ms. Jordan.
My lords, my lady. Just removing Mr Smith's stuff.
You're dealing with the vicarious liability.
Vicarious liability, yes, my lord. I'm going to address you as briefly as I can on the test, whilst doing a bit of a whistle-stop tour of some of the authorities, and then I'm going to apply them as briefly as I can to our facts. And I'm going to pay particular attention to the nature of the tasks, the nature of the duties. And then at the end, I'm going to address what I see as the two main points made against me. That's what I'm calling the narrowness point and the protocol point. So, my lords, my lady, the appellants urge you to reinstate the decision of Mrs Justice Charles on this issue. So could we look at the relevant paragraph of her judgment where she makes the finding, which is paragraph 182 at page 56 of the electronic bundle. And we've already looked at this. This is where she finds, or says at least, that the only duty he had was the investigating the address. And he, in taking her to his home and raping her thereafter, this was not sufficiently close to the duty, and therefore he was on a frolic of his own and he abandoned his post. That appears to be the size of it in my submission. It should be noted that no reason was given by the trial judge for her finding that he was on a frolic of his own or abandoned his post, beyond her finding that he deviated from the narrow framing in that paragraph that she put of his duties. But, my lord, in all vicarious liability cases involving intentional wrongdoing, there's always, though I say almost always for reasons I'll come back to, there's always a deviation from the wrongdoer's authorised employment activities. That's why the close connection test is necessary. And that test recognises that there will be a deviation, but the court has to assess the connection to the employment activities. Now, the closeness of the connection is not about the extent of the deviation. It's not about how far the employee deviated from his role. Thinking of the example of the boarding house warden abusing children in his care, that's the furthest imaginable deviation from someone's duties, isn't it? But there was a close connection because that deviance, that deviation, the wrongdoing is the deviation, corresponded to the duties. Now, in my Lord Borough's decision in the BXB case, it's at page 3452, paragraph 58.3, when he considers the link, he noted that the sexual abuse of a child by someone who's employed or authorised to look after the child will at least generally satisfy the test. So, in my submission, the harm and the wrong corresponds to the duty. It's a negation of it. Lord Millett, in the Lister case, at page 3218, paragraph 82, held, and it's this finding of Lord Millett that my Lord Burroughs had in mind, expressly had in mind, when he said what he said at paragraph 58. And Lord Millett, in the Lister case, at paragraph 82, and this is at B, in the middle of that paragraph, he said that it was an abuse of the special position in which the school had placed him to enable it to discharge its own responsibilities, with the result that the assaults were committed by the very employee to whom the school had entrusted the care of the boys.
I'm so sorry, can you give me the page number again?
It's page 3218, my lord, at paragraph 82B.
So
3218.
Ah, yes, thank you.
Now, my learned friend this morning sought to argue that there was some sort of special category in these cases. Well, my first point is that my Lord Perrose went out of his way in his reformulation or formulation of the test to say, well, they're not special cases. This is a flexible rule that should apply to all sorts of cases. And my learned friend referred to the task of the warden in the Lister and Halsey Hall case as an awesome task. Well, my Lord, there's no specialness about his task in our submission, and there's no specialness about sexual assaults, because it's all about the correspondence between the duty and the deviation. And to back that up, could we look at page 3215 of the bundle? And this is still the Lister decision of Lord Millett. And he based his decision in this case on a rather mundane in some senses in terms of the lack of awesomeness of the task, I would say, case of Morris and Martin. Now, it is an awesome duty to have a mink stole put in your care, some might say. But the basis of the decision, just 3215, paragraph 75. Yes, this is the Morris and Martin case. And he says, it was held, halfway down at B, it was held vicariously liable for the conversion of the fur by its employee. Lord Justice Diplock said that he based his decision, quotes, on the ground that the fur was stolen by the very servant whom the defendants, as bailies for reward, had employed to take care of it and clean it. And then after, at the very bottom of paragraph 75, the employee's position gave him the opportunity to steal the fur, but as Lord Justice Diplock was pains to make clear, this was not enough to make his employer liable. What brought the theft within the scope of his employment and made the firm liable was that in the course of its business, the firm had entrusted him with the care of the fur, and he stole it whilst it was in his custody as an employee of the firm. Now, it doesn't get less awesome a task than that, really. And somewhere else in this judgment, Lord Millett comes up with a hypothetical of, he says it can't be the case that you've got a greater obligation or at least a greater chance of being held vicariously liable if you're looking after a sack of potatoes than if you're looking after some young boys. So there's nothing special about those, in that regard, about those particular cases. So, my Lord, the extent of the deviation isn't the relevant factor here. It's whether the deviation corresponds to the duty. And if there's convincing evidence of an intervening reason for the deviation, sufficient to take it out of the realm of the employment context, that is, an abandonment of post or removal of the metaphorical uniform, then that would, we accept, sever the correspondence or the connection. So turning to think about other authorities, in my submission, there are two types of cases where, there's lots of types of cases, but I'd like to look at this in this way, if I may. There are two types of cases where no vicarious liability has been found. There are the abandoned post cases, the sort of, metaphorical uniform removed frolic cases, where something else was going on that motivated the deviation. So that irrespective of whether the person was on duty or off duty, there was simply no connection or correspondence due to the extra motivating factor that was something else entirely. And here I'm thinking of the Hartwell case, Morrison, and Merseyside. Motive was relevant in all of these cases. In Hartwell, it was his anger and jealousy. He quite literally left his post and tried to shoot his ex-lover's partner in a crowded bar. In Morrison, the auditor was, and these are cases we've already looked at this morning, in Morrison, the internal auditor was engaged in his own criminal enterprise, and it was his personal vendetta against his employer that was the reason why no vicarious liability was found. And then in Merseyside, in NV Merseyside, and that's at 3264, I'm not asking you to get it up just for your note, my lord, he was never on his employer's business in the first place. So the first reason for no liability in that case was he wasn't on duty, but the second one was that the evidence in that case showed that he was on the prowl, quote unquote, for a victim. And again, the motive was relevant. In all of these cases, the motive took the wrongdoer out of the realm of his employment, even if he was engaged in it in another respect. It was an intervening extraneous factor. So that's the first type of case where no vicarious liability has been found. The other type are cases where there was just no correspondence at all between the deviance and the duties, between the wrongdoing and the duties. The wrongdoer never donned the uniform or took up the post. And here I'm thinking of the BXB case. There it was the friendship between the victim and the wrongdoer that put her in the position where she was attacked. Case ended up in court, of course, because they also had a relationship arising out of the church membership and the elder status as an elder of the wrongdoer. And then the other case is MXX and A secondary school, and that's at 3262. And that was a case where the wrongdoer was on a work placement for just 1 week in a secondary school. And then he made contact some weeks later via social media with the person who had been attacked, who he had a sexual encounter with. And it was held that the prior school role wasn't a factor at all, and it was the contact on social media that set the ball rolling, and therefore it was just completely outside of the scope of the quasi-employment situation. So, my lords, in both of these types of cases, in my submission, there was something else going on than the employer's business. And that's how one, in my very respectful submission, ought to look at these cases. In the end, the cases I've just very quickly referred to were all ended up being mere opportunity cases. Here, however, in our case, Norman Bastian had custody of a woman described by the trial judge as in a very vulnerable and helpless position over a man who was endowed with a lot of power. Looked at that, it's at page 36 of the bundle, paragraph 114. That's the first point. Secondly, he misused and abused his power as an immigration officer. That's another finding. Paragraph 151 of the judgment. Thirdly, his employer placed her into his custody. She didn't find herself there. He didn't put her there. The appellants placed her there. And the finding of the judge is at paragraph 15. So page 16 of the bundle, paragraph 15. And I respectfully adopt what my Lord Briggs said about this. Because of that, Mr Bastian had to look after her until release or return. Because this position he was in as the custodian, is the term I'll use for these purposes, as her custodian, this brought with it duties on him to look after her basic welfare and to protect her from harm. And the reason he had these duties is because they were the duties that by law his employers had. And he was the representative of his employers, or the delegatee of his employers in this situation. And I've made this good in our written case, and by reference to Article 17 of the Constitution of the Bahamas and the Reeves Authority on the duty one has when you're a public authority and you're detaining people. That's the fourth sort of factual point. The 5, as well as being in his care, then, she was also under his control. His task as a senior immigration officer was also to investigate her. So the way I look at it, my lord, is that Mr Bastian's duties fell into different categories. There was his duty as a custodian, and that lasted until she was released or returned to the department, to the detention centre, and we know she was released. So that duty as a custodian lasted for all material times for this case. The second sort of class of duties he had were the duties of an investigator. He was investigating, he was in charge of Special Investigation, Fraud and Intelligence Unit at the department. And the reference for that is page 1863 at line 25. He was also given duties by his supervisory officer on this occasion to go and check her address and to interview her.
In fact, he invited his supervisor to give him that duty, but that doesn't, you would say, make any difference.
Well, it doesn't, and in fact, I'm grateful, my lord, but in fact, he didn't need to be authorised to do that. The only authorisation he needed from the Assistant Director of Immigration was to have, it wasn't an authorisation, but he needed her to be released into his custody.
Yeah.
Because had she been released unconditionally, if we just think about this, had she been released unconditionally and he walked up to her and said, hi, Claudia, Mrs Bethel, I'd like to come now, please, and see where you live, because I've concerns about the questions you gave in your interview as to whether you've been lying about your relationship with your husband and where you live. So I'm coming now with you. And obviously, he couldn't have forced himself to come with her. And she would have been within her rights, and presumably in her condition and situation would have said, well, how about we make an appointment for you to do that? How about you don't come home with me? So he needed to be released. He needed her to be released, and that was why he needed to call up his superior, not to ask to do his job, which is to investigate. And that takes me to the sort of third way in which I look at his duties. So first was custodian, second was he was the investigator on her case. The third was that, well, he was a senior investigatory officer with all of the powers and duties that come with that under statute. And here could we actually look at our case? Paragraph 108 onwards is page 2849 is where we deal with all of this in much more detail. And at paragraph 110 and 111, we've set out what his investigatory and general powers were. And he had all the powers and privileges, protections and authorities conferred by law on a police officer for and in relation to the investigation of an offence. And then paragraph 31 of the Police Force Act, I'm looking now at paragraph 111 of our case, refers, it's in the bundle, but refers to section 31(5) of the Police Force Act, which provides that for the purpose of this act and any other law, police officers shall be deemed to be always on duty when required to act as such. So my learned friend made quite a bit of the fact that, well, it's different in Merseyside because he was a police officer and he could self-authorise. Well, Mr Bastian was also able to self-authorise in that respect. Now, there were obviously constraints on what he could do, constraints of legality, and for example, chief amongst them is that he only had these powers in relation to the investigation of an offence. I think his evidence was that the offence he had in mind was the offence of giving a deceitful answer in an interview. But in my submission, it doesn't matter whether any of this was lawful. These were the duties he had. So my sort of seventh factual point is that, on the facts, is that, so he had these tasks and he had these duties. He didn't release her from his custody until after the wrongdoing. He took her to the police station the next day and told Corporal Butler that she's under arrest and has been since Friday, and that's at page 574 to 5 of the bundle. His own evidence also was that although he'd released her, his investigation into her situation was still ongoing at the time of her release. And that's at page 1954 of the bundle, at lines 4 to 23. And what he said to my learned friend, my learned leader, whilst being cross-examined, was that he hadn't written up his report of the interview because he was suspended on charge of rape before he'd got around to doing it. And as far as he was concerned, he was still conducting his investigation at that time. So that's where I come there to the end of my very brief look at the facts. You'll note there's no evidence here at all, my lord, about his motivation in taking her to his home and raping her. And it just wasn't explored by the appellants, who, by the way, didn't cross-examine Mr Bastian or any of his witnesses to put their case on vicarious liability to him. He wasn't asked about it. He didn't offer a reason for the wrongdoing beyond his defence of consent, which was rejected. So there's no basis to find, as Justice Charles did, that he went on a frolic of his own while still in charge of her. There was no extraneous motivation and no other explanation like there was in the Hartwell, Merseyside and Morrison cases. In addition, my lord, false imprisonment and rape are acts of control and coercion. And his role gave him powers and duties of control and conversion and coercion. And the rapes, we would say, and I caveat this by saying, acknowledge that we don't have evidence of what his motivation was, but one can't just assume it was sexual gratification or it was some other motivation, because rapes are acts of dominance, assertions of power and intimidation. And all of this is linked to his role and his position of power. And it's also linked to the finding of the judge that she stayed with him, went with him, because of this position of power that he held. So in my submission, like in the Lister case, the wrongdoing, the deviation, the deviance, was a direct misuse of the powers and duties that he had. And there you have the correspondence. There you have, we would say, the close connection. And unlike in the BXB and the MXX case, there was more than mere opportunity here. There was the correspondence of the kind present in Lister and Hesley Hall. Dare I say, correspondence of the kind present in the stolen Mink Stole case. So to adapt Lord Millett in paragraph 82 of Lister, he abused the position in which the Department of Immigration had placed him to enable it to discharge its responsibilities as in charge of immigration in the Bahamas, with the result that the assaults were committed by the very employee to whom the Department of Immigration had entrusted the care and control of the detainee. And in addition to my point about coercion and control, authorities who are holding people in custody, as I've said, have a duty to ensure their welfare, and he abused that position in order to harm her. So he had duties of care, duties or powers of care, control, and coercion. The false imprisonment and the rapes corresponded to each and were a diametric negation of each and every one of those, and one is enough, but in all three cases, it can be looked at in all three ways in my submission, and therefore it's unarguable in my submission that there isn't correspondence, as I'm calling it, close connection here. So far from abandoning his post, as the judge found, Mr Bastian clung on to his post and used it in order to carry out this abuse. My lords, I think I need to unbundle the wrongful acts, because I've been speaking in general terms about the wrongdoing, but here there are two wrongdoings, if you like, types of wrongdoing. There's the false imprisonment, and then there are the 3 rapes. Now, looking first at the false imprisonment, because one needs to look at them separately. It's an oddity of this case, my lords and my lady, that the Department of Immigration, in fact, authorised the false imprisonment. Mrs Bethel was being falsely imprisoned by the Department of Immigration before Mr Bastian took her, before the so-called release order. And what happened was, in my submission, they merely transferred their false imprisonment of her to him, but they carried on falsely imprisoning. Arguably, they carried on falsely imprisoning her through him. Now, my client probably would have had a direct claim for the entire period against the appellants on the basis that they had detained her for the entire 61 hours plus the extra 22 hours. But it doesn't matter and I'm assuming the reason that this didn't happen is because the disclosure of the release order talking about the custody her being put into his custody came about later. But it doesn't matter to this analysis that direct claim could have been brought and could have been successful and could have saved your lordships and the trouble of having to hear this case, but that's where we are. So we say the false imprisonment was actually in the course of his employment. It was or sufficiently close for the purposes of the test, but we say it was actually in the course of it because it was authorised. And just very briefly on this point of authorisation of the custody continuing, could we look at page 466 of the bundle, please? This is the so-called surrender order release. We've been calling the release order. Now, the typed up bit of this at the top states that the superintendent is authorised to surrender her for the purpose of effecting her release, for the purpose of effecting, her release. But then lower down under action taken at the very bottom, it says, in custody of Senior Immigration Officer Norman Bastian, instruction from AD, Assistant Director of Immigration, Dwight Beneby. So this did not have the effect of unconditionally releasing her.
In fact, further up, it says that the superintendent is herein authorised to surrender Mrs Bethel for the purpose of effecting her release, subject to the holder of a resident spouse permit as a spouse of Mr Bethel. Does that mean
Subject is the holder, my lord. I think they're just saying that she is the holder of a resident spouse.
Yes.
Oh, subject is the holder,
Yes.
beg your pardon.
So I guess they're saying that this is... Yes.
It's not terribly clear.
So it seems to be the case that they're quote-unquote releasing her because they can't hold her because she's the holder, she has legal immigration status in the Bahamas, to use the phrase that's being used. So that's why they were releasing her. But they didn't unconditionally release her. Instead, they put her into the custody of the Senior Immigration Officer.
I'm finding it quite difficult to read this bit of manuscript under action taken.
Yeah.
In
Right.
custody,
In
and the
custody.
stamp gets in the way.
In custody, under custody, we have Norman,
Yes?
First name of Mr Bastian. No, sorry, after custody, the other side of the date.
It's saying in custody of SIO Norman Bastian,
Yeah.
instruction from...
ADO Dwight Beneby,
Yeah,
Beneby underneath.
Yeah.
Okay.
Assistant Director Dwight Beneby. We are in the position of being able to look a little closer and see what this really meant, because as the Supreme Court judge, as the trial judge noted at page 34, paragraph 102, Mr Beneby's evidence was that a temporary custodial order ought to have been issued in these circumstances. Now, his oral evidence on this is very illuminating, and I don't know if we have time for your Lordship's and your Ladyship to read it now, but it's at page 1761, line 29 of the bundle, to page 1765, line 24 of the bundle. And what he says there is that what they should have done with the benefit of hindsight, and it seems certainly my Lady Yip has already read this from what she said earlier, that if things had been done properly with the benefit of hindsight, they would have, instead of doing a release order, done a temporary custodial order, because that would have required him to have brought her back to be processed for either release or charge. And in answer, and he offered this evidence. He wasn't being cross-examined on this. He offered this up. And then when my learned leader asked him the reason for this, it was so that you could keep track of detainees. So instead what happened, and he's not saying here, we took a different approach and we decided not to release her into his custody, we decided just to release her. He said the wrong form was used. And then at page 1768, line 31 to 1769, line 23, when asked about the status of these documents, the surrender order, release, and the temporary custody order, he said they're not official orders by any court, but he describes them as the administrative stuff that we do at immigration. So whatever the lawfulness of any of this is I'd say with respect by the by, because none of it was lawful. She was already being held unlawfully. They had no right to arrest and detain her, and certainly at this point they had to release her because they were well past their 48 hours before charge, or at which point they were required to return to the magistrate for either charge or extension. And so it was all unlawful. But they wanted to continue investigating her, so they held on to her. They didn't release her. Had they, however, done their quote-unquote administrative stuff that they do correctly, in the sense of administratively, legally it would still have been unlawful, but had they produced a temporary custodial order, then your lordships and your ladyship would have before you something that said, bring her back so we can process her for release or charge. So what in fact the employers and the appellants did was give Mr Bastian a blank cheque, an open-ended access to this vulnerable woman who had been and remained in detention. And Marcia Curry's evidence, which is at page 393 of the bundle, paragraph 8, and this was the friend of Mr Bastian who accompanied them on this odyssey they all went on, was that he was meant to return her to his boss, Beneby. So that's interesting. I would submit.
Sorry, I missed that page.
It's at page 393, milady, at paragraph 8. And she said, Norman took me to my shop and told me, this is when he was dropping her off, and said he had to take Claudia to his boss, Benaby, which rather suggests he had in mind at some point he was going to have to take her back to the detention centre. That is speculation, though, on my part. It's not clear. So that's the false imprisonment, and we say the answer is really very simple on false imprisonment. Not only was he in the course of his employment and sufficiently close to it, he was authorised to do it. Of course they're vicariously liable. Turning then to the sexual assaults, the rapes, well, he carried these out while she was in his custody, and while she was in the custody in which, as we've just seen, the Department of Immigration placed her.
Is there no procedure in the Bahamas whereby when a person's arrested, they have to be brought before a court?
Well, there is, and that's what I was referring to about the 48 hours.
Oh, I see.
Under the Constitution, there's much like here, I'm afraid I know more about the rules in the Bahamas than I do in this jurisdiction, but you have 48 hours to either charge, or to come before a magistrate to either charge or seek an extension.
Yes.
And they did neither. And I don't know if I can find it right now, but interestingly, Mr Bastian, when he was cross-examined about, yes, I found it, while he was being cross-examined, his evidence, when he was being questioned about why he didn't phone up and ask, because this is in the context of him saying, I couldn't find a female officer to chaperone, that's why I just took her anyway. And my learned leader asked, well, why didn't you phone up and ask the director to supply you with one? Because that was the rule. And he said, and I'm quoting, and this is a this is a page 1887, line 25. And in my submission, this is interesting. He said that he had discretion or latitude to do whatever it was to get that investigation going and to get Mrs Bethel out of the detention centre in time before that 48 hours passed. And then he specifically notes that this was so that my learned leader, Mr. Fred Smith, wouldn't be able to bring a case like this one against them. So that's...
So, is this release, in inverted commas, into the custody of the immigration officer a way around habeas corpus requirements, effectively? Well,
it looks a little bit like that, my lord. It looks like they, and when we saw on the profile document, it was signed by ADI Benaby that we looked at earlier. It was signed by him on this day, and it was referenced to there being a spousal permit, and so they thought, well, we have to release her now because this 48 hours and pesky Fred Smith case.
Which is released into the custody of an immigration officer.
Yes. So instead what we'll do is you can take her and do your search. And yet another breach of protocol and gross unlawfulness here is that there was no warrant to go and into this woman's apartment and compliment her on her bedroom set, which is what he did. So he may well say, well, this is how you find out whether these people are pretending to be married. You turn up either unannounced or you take them from the detention centre against their will and check their property. But it's unlawful. You need a warrant for that.
Do the magistrates' courts sit on Sundays in the Bahamas? I'm just wondering how, if you arrest somebody in the small hours of Saturday morning, you can effectively get them before a judge within 48 hours.
You could look at the
Tamara Merson case explains? Lord, if you look at the Tamara Merson case, it explains all of this. The Merson case that I referred your lordships to earlier, that explains all of the situation that continues to exist.
My answer to my Lord Morbrig's question, which is avoiding answering it, but is saying we're at 3 o'clock on Monday now, so there had been plenty of time at that stage.
Oh, yes, but I'm just wondering how the 48 hours...
How it works.
Whether there's some ability to extend it or something of that kind.
And there's no emergency sitting or ability to get before magistrate over the weekend in the Bahamas.
Well, there we are.
I obviously know less than I thought I did earlier.
Yes, I was thinking about in a past life having to deal with football matches and emergency sittings.
Yeah. So we're just getting back to where the point I'm making. We're looking at the rapes here, and my point is they were carried out whilst very much in custody, to which these employers, the appellants, had placed Mrs Bethel. So he was the custodian of her, actually or ostensibly. Ostensibly would have been good enough in my submission on the authorities, but really was actually for the whole time. So he was in the course of his employment. We don't even have to get into close connection until he released her. And it's a make-weight point, but it's a neat point in my submission that the evidence shows that he went in to a police station after the rapes and openly said didn't allow, or at least Mrs Bethel didn't do any of the speaking. She was going in to find out about her, to find out the report of where she had reported her lost permit. And he did the talking and said, she's under arrest and has been since Friday. That's the evidence. My learned friend cast aspersions on this as evidence of the fact that she was still in custody. And my reply to that is what Lord Steyn said in the Bernard case. And that's at that's at page 2989, paragraph 26. And this is the case where the poor chap was shot point blank in the face for not giving up his space in the telephone queue. And then when he came round, he was put under arrest. And Lord Steyn held this was retrospectant evidence that at the time when the wrongdoing was carried out, he was, at least ostensibly, or thought he was, on duty. And it's not about the legalities of whether necessarily he was. It's about what he understood, what she understood, and what was ostensibly the case. Notwithstanding my primary case is he was on duty and it was part of his role. So there's the Butler evidence, and then there's the evidence that he was still investigating her, which I've referred to. That's at page 1954, lines 4 to 6, is his evidence that at the time of his suspension on the rape charge, he was still investigating her. The way he put it was, he was finished with her, but he wasn't finished investigating her. So clearly he abused that position of custody, of care, of control, and so the correspondence between the duty and the deviance, it's a perfect correspondence, as in Lister. So we've seen it, we don't need to go to it, but at page 153, paragraphs 237 to 243 is where the Court of Appeal overturned Charles and where Sir Michael Barnett set out the facts as found by Charles, and just as I've just summarised, and found that the close connection test was satisfied, and in our submission, he was right to do so. So I have about 10 minutes, my lords, which is, I think, all I need, because I just wanted to address, to the extent I haven't already done so, and I've mostly done so, the two discrete points, as I see it, that are made against me on this. And one is what I call the narrowness point, and the other is the protocol point. So the narrowness point is that for close connection purposes, you're only allowed to look at what he was actually authorised to do. Now, I've made probably lengthy submissions on what he was authorised to do. But I think one of the points my learned friend's getting at here is that he wasn't authorised to take her off the premises without a chaperone, and that somehow then he's not authorised. As I understand my learned friend's, that's how the case is put in his case. As I understand his submissions this morning, he changed it from the lack of a chaperone vitiated the authority to the lack of a chaperone tainted the authority. So I think his position is that it's to be taken into account in the mix when you look at the test, but it's not sort of a threshold problem. But in any event, even if your lordships are concerned that maybe it did vitiate the authorisation, we say that none of what we've been discussing, all of those duties and powers and obligations are vitiated by the lack of a chaperone, or by the fact that he said to his supervisor that he was going to have a chaperone, but in fact didn't. He was still charged with doing these things, and he still had these obligations. Yes, of course he should have gone by the book, although it's hard to know how you go by the book when you've been given an illegal detainee to illegally take off the premises to illegally search her property. So the appellants are trying to wash their hands of liability for this on the basis of a judge's finding that Mr Bennaby was deceived about whether there was a female immigration officer with him, when, in fact, as we've seen, his supervisors gave him extraordinary latitude. His supervisors and his statutory rights, but his supervisors particularly gave him extraordinary latitude that extended, as I've said, to authorising him to inspect her home, keep her in custody, when there was no offence suspected, no warrant, and it was all unlawful. So it's ironic in my submission for my learned friend and for the appellants to seek to avoid vicarious liability on this technicality about whether or not it was authorised when everything else was unlawful. And the protocol point then, which overlaps somewhat with that point, is that his breach, as I understand it, the argument is that his breach of the rule, the chaperone rule, detracts from the close connection. So, given it's been admitted now, I've dealt with that even if it vitiates authority, that doesn't work. But even if it just taints the authority he had, in my submission, that's really then a policy argument about how maybe this, looking at my Lord Burroughs, how maybe someone should have another go at this rule and adds another sentence in that says, well, if you're breaching, if you breach protocol somewhere along the line, you're outside of close connection. Because the wrongdoing is the deviation. You've got the duty, you've got the deviation. The deviation's the wrongdoing. I think what my learned friend is saying is that it was a deviation from a deviation. Because the first deviation was going without a chaperone. That's not the wrongdoing we're looking at. We're looking at the deviation from the deviation, which is the wrongdoing. And if you're conducting the close connection test, I think the way my learned friend is thinking of this is that you're being asked to look at the connection between the wrongdoing and that deviation, the breach of the chaperone point. And So it's a policy argument. You would have to decide to do this because it's not consistent with the test, in my submission. And in my submission, it's bad policy, because if breach of protocol by employees is going to protect employers from vicarious liability, then there's no incentive for employers to ensure protocols are adhered to, is there? And this would have particularly disturbing implications in grooming cases. If a deviation from a deviation means no vicarious liability, then that ends the possibility of vicarious liability in grooming cases. Because their course are categorised by incremental safeguarding breaches, leading eventually to the wrongdoing, capital T, capital W. But if you can escape liability as somebody who runs a care home institution on the basis that, well, yes, there was a gross breach, but it was only carried out off the premises, and that was the safeguarding rule that was broken. We weren't allowed to go off the premises. Going off the premises isn't the wrongdoing. That's just a protocol breach. Well, then you can... I don't need to finish the sentence. It's clear where that's going to end up. So, as we're required to do then in these cases, my Lord, just the final check, and that is to look at, for all these reasons, we say the finding of vicarious liability is in accordance with principle, but as a final check, we've got to ask ourselves, is it in accordance with rationale? Now, the origin of the rationale for the principle is referenced by Lord Millett in Lister, and it comes from Atiyah, and it's at page 3212, paragraph 65.
65 or 55?
65 is what I said.
just didn't hear it.
I thought you had some deep
No.
knowledge of exactly
No, certainly not.
it wasn't. You were correct. I wouldn't be surprised, my Lord.
No, I just wasn't sure I heard you correctly. 65.
And the rationale is the wrongdoing reasonably incidental to the type of business that the employer is carrying out? And the answer to this is a resounding yes, of course. The last sentence of paragraph 65 there. The risk of this type of wrongdoing is inherent in the nature of the business. And my Lord, that this risk is inherent, clearly it's inherent in the business that the immigration department is doing, that detainees or members of the public are going to suffer abuse at the hands of people with these extraordinary powers. Clearly it's a risk. And that this risk is inherent is, we say, precisely why there's a chaperone protocol. It can't be the case that the wrongdoer ignoring or breaching the chaperone requirement absolves the employer. So it's part of the risk. It's inherent in the business that the immigration department's doing. Inherent is the obvious abuse. And as part of that, a risk that the chaperone safeguard isn't observed or doesn't work. In my submission, Mr Beneby was very nonchalant and relaxed about this in cross-examination when he was asked by my learned leader about, sure I have the reference, I have to find it in a second, when he was asked about, by Mr Smith, KC, how he goes about ensuring that this protocol is observed. He said, well, Mr Beneby had training and I trust him.
Now, Ms Jordan, you're going to have to draw to a close very soon so as to allow time for a reply. That's
in fact the last thing I wanted to say, my Lord. But all I wanted to do was give you the, well, first of all, so my point is that the employer can't avoid liability by putting rules in place and then saying if the employee doesn't abide by them, they're not liable. So unless you've got any questions on this vicarious liability point, I just want to give you the reference that my Lord Sales had asked for.
Oh, thank you, yes.
Just before you do that, I have a question, if I may. We're, I think, in agreement that Mrs Justice Charles did apply the correct legal test on vicarious liability. So how do you say that the Court of Appeal was entitled to overrule what was decided?
Because the application of the test is a point of is a mistake of law. The wrong application of the test was a mistake of law on her part. So she had made all of the right findings. Everything was there in the judgment. Everything I relied on in my list of facts were findings. But she then didn't marshal them when it came to this bit of her judgment. The finding, the interesting findings are paragraph 114 and 151, where she talks about the way, the power, the effect of the power of him as the power he was endowed with. He abused and misused the powers endowed with. They were all findings she made when she was thinking about whether he'd falsely imprisoned her. But then when she came to paragraph 182 to think about vicarious liability, she failed to take them into account. So we have no qualms with her findings of fact. We've no qualms with her idea of what the test was, but she didn't put the two together to come up with the right answer in our submission, as the Court of Appeal found.
Thank you. And then the reference that you gave us, could you just check that that was correct? The reference from Millett, Lord Millett. I wrote down 3132, paragraph 65, but I think I must be mistaken, because that doesn't appear to be.
Well, it starts on 3131.
3131?
Yeah. 3211. 3211 and goes over to 3212.
3211.
Yeah.
Ah, well, that's my mistake then.
I'm grateful, my Lord.
And Mr Jordan, I think also in relation to the answer to my Lord's question, I understood you to be saying, in effect, from almost your opening point, that there is a straightforward error of law in paragraph 182, where the judge said Mr Bastian had no duties beyond investigating and so on.
Yes, I'm grateful.
I just wanted to make sure I'd understood the submission.
She made findings elsewhere. 179, she talks about his wider duties. So she has made the findings she needed to make for our purposes, or we needed her to make, in order for the duties to be there. But when, again, very similar error in my submission, when she comes to think about vicarious liability, she just talks about that narrow duty. I'd put it like this: she's drinking my learned friend's Kool-Aid in terms of making it too narrow.
Right. I was just asking for your confirmation that I'd understood your submission correctly, not asking.
Yes, so the factual finding is there. It's just an overly narrow approach.
Yes, thank you.
So the reference, my Lord said,
Yes,
looking
thank
for
you.
earlier, the evidence in support of what's in paragraph 131
Yes.
is 1565, if I'm reading my learned junior's handwriting, paragraph 26. And the note, the reference I didn't have earlier about what Mr Beneby said about how he makes sure that people are looking after protocol is 1759, line 7. 1759, line 7. That was his nonchalant, in my submission, approach to these questions.
Thank you very much.
I'm grateful.
Thank you very much, Jordan. Yes, Ms. Pennington-Benjamin.
Thank you. Thank you very much. I'll just respond briefly to the vicarious liability point and then retrace my steps briefly on the unlawful arrest. Just to clarify what I'm saying about the authorised acts versus the unauthorised acts point. I don't think I am asking for any change in the law. I'm simply saying that the facts preceding and surrounding the tort have to go somewhere. So, as part of the close connection test, the court has to, on the one hand, look at the authorised acts, and at the other end, on the other hand, look at the tort and see how closely connected they are. But you can't ignore all the other facts. So those facts preceding the tort and surrounding the tort, for example, whether the revolver was taken in breach of permission, whether there was a breach of protocol, whether there was some rule or safeguard that was breached, those facts have to go somewhere. And my submission is, as a matter of logic, they have to go into the intellectual space that appears after one has delineated the authorised act. The authorised act is this, and then the tort and all the facts and circumstances surrounding it and preceding it then have to be looked at to determine whether there are facts connecting or detracting from the close connection. And I'm simply saying that that is entirely consistent with the approach of the board in Hartwell and in Bernard, but it just hasn't been articulated that way. The way the test is articulated is you compare the authorised acts with the tort, but you've got to obviously take into account all the other facts, because there could be a whole load of stuff that's done before the tort that is relevant to the question of whether there's a connecting act. And that stuff includes breaching protocols, taking revolvers without permission. And the judge is absolutely right to look at all of that material, not just to ignore it. I do take the point about duty and the corresponding liability in respect of the child abuse cases. I think that's a fair summary of the case law in that respect. But I do respectfully submit that it's unrealistic, for the purposes of the close connection test, to say that he owed a duty of welfare arising out of custody in his capacity as an immigration officer. His duty as an immigration officer and the welfare obligation was whilst he was authorised to have her in his custody as an immigration officer. His duty then was to release her.
Well, or return her.
Sorry? Or return, yes. But if he doesn't
hold
return...
on to her in the absence of being under any duty as to what happened then.
I think the more important point is that at the moment he decides not to release her or not to take her back, he's then holding her in a different capacity. He's lost the authority of his office at that stage. That's what the judge is saying. Now, I understand there might be arguments about how that operates under the general law, but for the purpose of the close connection test, you can't proceed on the basis that he is continuing to hold her in his capacity as an immigration officer.
When was the moment he decided not to release her or take her back? He took her to the police station the next day and said she was still under arrest.
Claimed falsely that she was under arrest, yes.
But when was the moment he decided not to either release or take her back?
Well, I don't think I can point to a moment in time, but what the judge is saying, in my respectful submission, is his duties had came to an end. He knew that. She knew that. And from that point onwards, he's detaining her for his own personal... I don't think we need to look very far into the motivations beyond what he did. I mean, he's then detaining her for totally his own personal reasons. It's got absolutely nothing to do with his duties or responsibilities. And if one takes an overly sort of legalistic approach to the close connection test, one gets lost in this idea of duties and continuing duties. That's not the point. It's authorised acts. What was he authorised to do? He was authorised, so the judge found on the evidence. There's been a lot of references in my learned friend's submissions to bits of the transcript and stuff that was said in the evidence. I'm focusing on the facts that were found by the judge. She said his duties came to an end, yet he continued to hold her. That's what matters in our respectful submission.
Might it not be said that the duties, if you've got someone actually in your detention and therefore in your control in a very specific way, extend beyond simply holding them or releasing them, but also extend to not abusing that power of control that you've been given over them?
Well, certainly once the detention moves over into his own personal gain, he's obviously abusing his position as an immigration officer. I accept that. But it's unrealistic and unhelpful in the close connection framework to treat a period of personal detention in his house as if it was immigration detention and say, well, he owed her a duty of welfare and he breached that. I mean, that's just not a fair comparison with the institutional abuse cases, for example, where, I mean, the whole point is if you take someone out of that environment, you do start embarking on a sort of frolic of your own, and whether or not that is closely connected to the responsibility that you're actually given and the authority that you're actually given is the question. And that's the question that the judge addressed. I don't respectfully accept that she committed any error of law or principle. She applied the correct text and reached a proper conclusion on it. Just in terms of the arrest, verification was not a basis for the detention. It's a reasonable suspicion that there's no immigration status. And then, obviously...
But so just on that, presumably the onus is on the state as the detainer to justify
Yes.
the detention.
Yes.
I think the only witness put forward as capable of doing that on an O'Hara basis was Detective Curry. And if I can put it this way, he was very hands-off so far as the arrest was concerned. I don't think he even gives evidence that he knew that Miss Bethel had a copy of the spousal permit. And so he didn't apply his mind as to, well, is this a genuine document, or do I have a suspicion that it might not be genuine? He just didn't go through that process at all.
I think that's fair to say, because he couldn't have done if he didn't realise that she had it at all. But I think
and I mean, one could theoretically have said, well, he passes the baton over to others when the people are taken to the police station and then at the CGU. But in fact, no other witness is put forward by the state to justify the ongoing detention. So all we're left with is Detective Curry, I think. Is that correct?
I accept that, my lord. And of course, there is a point there about who was the arresting officer. And I think the judge says, well, he was the arresting officer, but what she means is that he was the officer that authorised the arrests. So he authorised the arrests, and the other officers acted as his agents effectively in effecting the arrest. Because what you couldn't have in a group arrest situation is 10 different officers all forming their own independent...
I mean, the long and short of it is that no one on the state side challenged her evidence, which the judge accepted, that she showed it to a police officer before being carted off in the van.
Yes. And indeed, she was telling people at the police station that's what she had done, and no one.
Well, it was challenged. Sorry, it was challenged. My own friend, I mean, their case at trial was that that wasn't true, but the judge found against us.
Yes, there wasn't any evidence to challenge it, as I understand it. It was just not
put to her.
That she showed it at the outset wasn't met by any evidence of your side, as I understand.
I see there was no positive evidence because it could only come from Curry, but we were putting it to her on instructions during the trial. Sure. So the state's case was, no, you didn't show it to the police. But yes, we were. You might think unsurprisingly, the decision, which we've accepted since, was no, okay. And that's what Mrs Bethel said, and no one's in a position to say that that's not correct.
So when one goes back into the evidence given by Detective Curry about the information he was given, as Mr Smith pointed out, it was in terms of there are exotic dancers at the club who may be in breach of immigration controls. And then the point is made against you that when Detective Curry goes in, it's very clear that Mrs Bethel isn't one of the exotic dancers to whom that intelligence related. So what do you say about that?
Well, what I would say about that in broad terms is that Inspector Curry gave evidence over 3 days, and he did point out in his evidence that there were 2 separate points. One was the immigration status and one was the exotic dancing. He treated the exotic dancing as a potential public order issue and the immigration status as
Right, but the point by all means show us the passage, but the passage I've got in mind is where the persons identified as potentially committing immigration offences are the exotic dancers. In other words, it's not saying, and they're guilty of something else as well. They're guilty of immigration a group of people are guilty of the immigration offence, how do you know what that group is? They're the exotic dancers.
No, I don't think his evidence is as clear as that. I mean, other than going all the way through it, it's quite difficult to make the point, but he does separate out the two, especially, for example, at 1370. I don't know if it's the better one. I mean, it was put to him at line 16, that is all there was. You agree that all there was the suspicion of exotic dancing. I mentioned illegal persons, and I think this is what the judge is getting at, is that there are two separate sort of points that are being made. What I can do is give a series, I mean, I don't want anybody to have to read 3 days of evidence, but can I give some references to some of the pages?
Sorry, just so that you can deal with it, the passage I had in mind was page 1367, where he's asked what information were you provided with by way of intelligence.
Yes.
Line 11, there were suspected illegal immigrants performing exotic acts in the club, and he returns to the point at the bottom of that page. So in other words, what I'm putting to you is it seems to be his evidence is the intelligence information he's given is focused on the exotic dancers at the club. And he goes in, Mrs Bethel isn't an exotic dancer.
Yes.
So it might be said there's a bridge that the state needs to get over between those two things. Are you going to suggest how he can get over that?
Well, I think it's simply the point that having asked the officers to check the documents of everybody there, nobody is able to produce any documents that none of the other persons have any documents, let's say, that evidence immigration status, and then she is also asked to produce documents. She only has the copy, and as the judge found as a fact, she was therefore, that wasn't accepted. She was taken in for verification of that document. That's her finding.
Well, Secretary Curry isn't aware of that
No.
anything's been produced.
I mean, I can see a case if the document's produced to Curry and he says, come off it, that looks like an obvious forgery, or give some justification why he doesn't accept it, that one then may be in the realms of he does have a continuing suspicion, notwithstanding a document produced, that an immigration offence has been committed. But he doesn't even get to that point. He forms no view at all about the document that Mrs Bethel is putting forward as her answer in the immediate circumstances to the allegation that she's an illegal immigrant.
No, I think he just accepts as, in his evidence that if there were a copy had been produced, it wouldn't have made any difference. He still would have taken her in. I mean, that's as far as his evidence goes.
All right,
he says, well, I would have taken her in, and therefore, because it's 2 o'clock in the morning, I turn up on information that there are a group of illegal immigrants there who are working on the black economy. I turn up, that's exactly what I find. Mrs Bethel is there working too, albeit in a different capacity. She, as far as he's concerned, she doesn't have a permit, but even if she did have a copy, he would have taken her in too for verification. And the judge makes a finding of fact, well, that was the basis of her arrest. And we're including, of course, the point, it's not just the immediate circumstances of the arrest. One can also look at what happens at the station as well.
Well, sorry, but that was my starting point. No one seeks to justify the continuing circumstances of detention at the police station in terms of grounds of suspicion of arrestable offences and so on. We just have Detective Curry.
Well, we do also have Mr. You then were looking at the immigration department's evidence of after that, but at the police station, I accept. I mean, it's just taken.
All right, thank you. But the starting point for this was you saying verification was not a basis for the detention. What was the basis for the?
Well, sorry. What I was trying to say is, I think it was put against me. Well, you can't detain someone to. Arrest and detain someone to determine whether an offence has been committed. I was just making the point that, first of all, there's a reasonable suspicion that she doesn't have immigration status. And then, of course, because you're only looking at that stage at a suspicion, of course you then do determine whether, in fact, an offence has taken place. There's nothing wrong with that. I mean,
providing you have the suspicion.
Sorry?
Provided you have
Provided you have a suspicion, exactly. But there's nothing wrong And we don't shy away from the idea that the police will then determine, once they have someone in custody, whether an offence... You don't have to determine an offence has been committed, just you have to have a reason.
Oh, of course.
Yeah. Sorry, it's an obvious point, but it was just taken against me quite forcibly.
Yes. But I think it's inherent in what you've just said that you wouldn't quarrel with paragraph 215 in the Merson case, to which Mr Smith took us.
I'd have to remind myself.
It's in the corrective additional document.
Probably.
It's page 47 of that.
I think it's along the lines, you can't just take people into custody and then decide to investigate stuff later, basically. Is that about the size of it? There's nothing in the law which precludes the power for investigating offences even during the trial, but they cannot have any power in normal times to arrest and detain while they look to see if there is any evidence that the person may have committed a criminal offence. Well, I'm not sure about that. I mean, reasonable suspicion can be based on intelligence, which is a form of evidence, and it's at a nascent early point of the investigation. Necessarily, the facts are unclear at that stage, and as long as there is a reasonable basis for a suspicion, which is a relatively low threshold, you can indeed arrest somebody and then go and collect evidence, including by interviewing them and other people, and determine whether an offence has been committed. So, I don't want to get lost in the words of this, but you have to have something, some basis for the suspicion. That's it. But I don't accept you have to have all your ducks in a row and the evidence ready and everything set out.
No, that's not being suggested.
No.
Now, how are we getting on?
Can I just have 2-3 minutes? Is that okay? Sorry. Can I just emphasise in respect of the necessity point that the Hayes decision, which is at 3168, although we don't necessarily align ourselves with Sir Michael Barnett's dissenting judgment on the false imprisonment point, because he does make findings that the judge didn't find about the additional basis that she was in charge of the other women. What we do commend to the board is the statement that His Lordship makes at paragraph 195 of the judgment, which is at 120, which is about the judge's approach to the facts and that the court shouldn't intervene. In respect of the Immigration Act, can I just ask the board, I'm not sure the whole act is in the bundle, but section 19 that deals with the requirement for a person coming to the Bahamas to have entry clearance, what we call in England entrance clearance, and then at section 28 that deals with overstaying any period that has been granted for leave to remain. So we do say that there is effectively an offence if you enter without leave or remain without leave.
Sorry, did you say we do have it in the
I
bundle?
don't think we do, but
Right.
it's sections 19 and 28, and it's very easily achievable on the
Yes.
internet, but I can send it to the board if necessary. Just wanted to highlight those 2 points. I didn't appreciate, I'm afraid, the subtlety of my learned friend's argument on paragraph 134 of the judgment, I'm afraid. I mean, I'd just taken the judge's finding that the position had been verified at the station as read, and that was the finding that the judge made, that maybe that the judge made a mistake about that, but I think I would align myself with the point made by my Lord Sales, that if anything, that's a finding in favour of respondents.
But as my lady pointed out, you have to read that with 135 as well. At all events, it seems quite, it might be said, confused reading through from 131
Yes.
to 135, what the judge is finding as a fact and what the judge is making of such facts as she's finding.
Yes, but for that whole period, of course, there was a finding of, I mean, just to make the obvious point, that's already been found against us. I mean, for the period in the police station, it's already been found against us. And I mean, there was references to the allegedly inadequate approach of the immigration officers to the question of whether they could detain. And again, that was all found against us, and we've accepted all of that. The point we're concerned about is the prior point, which was the facts as they were facing the police at 2 o'clock in the morning, when they had 15 odd minutes or something to conduct a raid and make a difficult decision about whether to take people into custody or not. And what we're saying there is, okay, it's not a slam dunk case, but actually in the round, if one accepts and gives proper weight to the judge's findings of fact on primary points, it's justifiable and it shouldn't have been interfered with, just particularly on a bare disagreement with her assessment of the live evidence. Can I just make one final point? I'm sorry, it's actually a vicarious liability point that I should have made earlier. Can I just ask the board to bear in mind paragraph 39 of the judge's judgment, which is at page 21 of the authority bundle, in the context of what we say are the two reasons why Mrs Bethel decided to remain with Mr Bastian. It was also the point that he was saying that he knew dangerous people called death, that he had a licensed firearm, which I'm told is a personal, not service firearm, and therefore that also needs to be slotted into the factual matrix. I certainly don't accept, by the way, on that point, that the judge somehow lost sight of all of these really important findings when she was making the vicarious liability judgment. That's plainly not the case, and that's not the usual approach that appellate court would take to a judgment, to assume the judge just forgets stuff that she's found earlier on that's obviously very important and central. Those then, I think, are my reply submissions. Yes, hello. Oh yes, I'm instructed to just make the point in response to Mr Smith's suggestion about promotional. Mr Bastian, I'm told, is retired, was forcefully retired in the public interest as a result of what happened in this case. Thank you. I don't have any other submissions unless there are any questions from the board.
No, I think not. Thank you very much,
Thank you so much.
Benton. Well, we're most grateful to all counsel for their assistance. We'll take time now to consider the advice that we will humbly tender to His Majesty.